So, good morning, everyone. Thank you so much for joining us this morning to our webinar on the Employment Rights Act 2025. It's going to be a rip-roarer over the next hour, so we're looking forward to it. The Employment Rights Act, as you may well know, is the largest piece of employment legislation we've had for a long time. It was introduced to improve employee protections, which the government say will bring us from amongst the worst of all the OECD nations when it comes to employee protections to nearer the average. And whether you think that's right in principle or not to do these things, it's going to have cost, time, and risk implications for all of us employers. The reason we're doing this now is obviously the Act came into being having been discussed for quite a long time. It was finished its parliamentary stages just before Christmas, and changes are being introduced from now through to the end of 2027. In many cases, we're still waiting for some of the regulations to come out for the finer detail of how things are going to be expected to be done, especially those things that are coming later on in the year and into 2027. But we will obviously keep everyone updated as things get clarified. We think this is probably just the first of 2 or 3 webinars that we will do in order to keep people abreast of the changes as they come through. What we can tell you about today is the main changes, when they're happening, and how you need to adapt to them. So let's have a little look at our agenda before I introduce the team. So we're going to do some introductions. We're then going to look at the Act and its implementation broadly chronologically. So we'll start at the beginning with what's coming first and work our way through. We're going to give you all the content first, and then we're going to focus a little bit on action planning. We're going to draw the lessons out from it and just summarize what kind of actions we think we all need to be taking. Then, obviously, how we can help you with all of that. And then questions. If you can please put your questions into the Q&A on Zoom. We're going to do them at the end. We'll make sure there's time. And we will, as I say, get through the content and then we will come to questions afterwards. So as things come up for you, please pop them in the Q&A, and the Q&A, please, rather than the chat. And we will definitely get to them. And if we don't get to all of them, we'll follow up with you afterwards, obviously. A couple of other housekeeping pieces. We're recording the session, so we'll send you a link afterwards so that you can view it again, and we'll send you the slides. And of course, we're happy to follow up afterwards. Here's the team. This is the HR services team here at Menzies LLP. And the people that you will be hearing from today are myself, Lorna Brock, Chris Miles, and Beck Kingsnorth. And Sandra is in the background marshalling your questions and will provide those to us nearer the end. I'm going to make a start with the first topic, which is unfair dismissal and the day one rights for unfair dismissal, which was widely touted and received most of the headlines, probably, in the run up to the Act, because the government were talking about making unfair dismissal a day one right. So just to remind you, currently employees need to work for 2 years continuously before they have the right not to be unfairly dismissed. And this gives employers the opportunity within that first 2-year period to dismiss employees who haven't worked out easily. In other words, without having to go through the full performance or disciplinary procedures that would normally be required. Now, fortunately, after consultation, this wasn't made a day one right. It's been reduced from 2 years to 6 months. But this will still draw in an estimated 6.3 million people who are going to acquire the rights to unfair dismissal who previously wouldn't have. That's the estimate. And so it is going to drive the need for much more attention to detail and process around performance in those early stages of someone's employment. So the things to think about, first of all, we need to think about timing. This is one of the reasons why we're talking about this first in our chronology, is that actually it's already in effect. The change is coming on the 1st of January 2027, but it's being applied to people already employed on that date. So, in a sense, it's retrospective. So, what that means is that if you recruited someone last September who ordinarily would have 2 years to claim before they could raise a claim, i.e., until September 27, they're going to acquire that right on the 1st of January 2027. So, in effect, they've got a 15-month wait period. Anyone you recruit today is going to gain the right in 11 months. And anyone you recruit from the 1st of July onwards this year is going to have that 6-month period before they can make a claim. So, a couple of things we need to think about here. First of all, probation periods. Many probation periods are 6 months long. But if you apply your 6-month probation period and review it at the end, you risk tipping over into that period where the employee will be able to make a claim. And it's likely at the end of a probation period, you're not really going to want to then have to go through a full procedure in order to, if it hasn't worked out. So many people need to think about changing the probation period. So, for example, it could be 3 months, allowing the ability to extend it for a couple of months if necessary, but then still give effect to that dismissal before the 6 months is up. There are obviously other ways of doing it, but that's one example. And just bear in mind when you're calculating someone's continuous employment, you need to include their statutory notice period in that. So, for example, if you dismissed someone, told someone right at the end of their 6-month probation period they were dismissed, you have to add on their statutory notice period of 1 week. So you could accidentally tip over. So that's just something to remember. So there are implications here for reviewing contracts to amend probation periods, but also to make sure that we're managing performance during those early days very tightly, that we're onboarding people well, we're making expectations clear, we're helping people to get up and running as soon as possible. We need to have good KPIs. We need to have managers who are skilled at managing performance so that we can do that well and efficiently during those early stages. And of course, making good recruitment decisions in the first place is even better. Just a point though, remember that this relates to unfair dismissal claims. There are existing day one protections where claims are around discrimination or whistleblowing and a few other topics, and those haven't changed. This is about unfair dismissal. But there's another change, the last line on that slide, which looks sort of innocuous sitting there at the bottom, but actually this could be quite a big deal. There's another change on the 1st of January, which is that they're removing the statutory cap on unfair dismissal compensation in the employment tribunal. So currently there's a cap that says if you go to the tribunal for unfair dismissal, the cap is either 12 months' pay or £118,000, whichever is the lower, and that's the maximum compensation you can receive. They're lifting that cap, then they're abolishing it. And that could significantly increase our financial exposures by allowing tribunals to award full financial losses. So that could include people's bonuses, equity. If they're in defined benefit pension schemes, it could even take account of those potentially lost earnings. So we could see much higher value awards, especially for high earners or maybe people in the public sector who have substantial defined benefit pensions, for example. So we're likely to see much more complex claims at the tribunal. A more kind of realistic, a day-to-day impact that might have revolves around the fact that most cases don't make it to the tribunal. They're settled in advance. And so this is going to have an upward pressure on settlements. It's always useful when you're negotiating a settlement with someone to know that if they went to tribunal, there's a cap that wouldn't, and that's a good limiting factor for your settlement. That might it's going to disappear. And so even settlement agreements are going to be much more pricey, potentially. So this is going to put much greater scrutiny on HR decision making, the use of proper procedures, and it's going to put more pressure on the tribunal system, which is already very backlogged, but the government says it's looking to address those issues. So a real focus on doing things properly. If we want to put downward pressure on a settlement, we need to effectively probably get further into the right process so that someone who we might be wanting to settle with can see that the alternative is a potentially fair dismissal, which means their claim should reduce. Anyway, we could talk about that all day, but that's enough from me at the moment. I'm going to hand over to Beck, who is going to talk about what's happening from April. Beck, over to you.
Thanks, Ed, and good morning, everyone. Next slide, please, Sandra. Okay, so from April, we're going to see a massive change in statutory sick pay. So the right to statutory sick pay from day one of sickness rather than day 4, and from the start of employment. The removal of the lower earnings limit, so all eligible employees, regardless of earnings, will have access to SSP. Employees are to be paid SSP at a rate of 80% of their normal weekly earnings or a flat rate of £123, whichever is lower. So what does that mean? So statutory sick pay is the legal minimum sick pay that can be paid to an employee when they're off sick. And right now you only get it if you earn £123 a week, and it starts from day 4 of absence. Now, I will say that if you have a company sick pay policy, if you have a company enhanced pay, this probably isn't going to affect you as much. But for all those companies that are just paying statutory sick pay, you're going to start paying that from day 1 of somebody's absence and from day 1 of their employment. So again, you may also see increases across your workforce in those one-day absences where they may not have taken absences previously because there was no pay for it. And yes, it is only statutory sick pay, but you still will see an increase, or we believe you'll see an increase. So what next? Oh, excuse me. You're going to need to look at updating your policies and contracts to remove that 4-day waiting period and the earnings limit. And also use this as a chance to check how your absences are being managed, how they're being recorded, and how you're reporting it. Because obviously, if you're allowing people to get paid for it, you're going to need to report on it because it's going to affect your bottom line. So again, with that in mind, it's about reviewing your budgets, ensuring that you've reviewed your staffing budgets, as this is going to have an impact for those day 1 absences that have previously been unpaid. A bit of an example there would be that at the minute, if you're paying somebody who's off sick for a week, you're probably going to pay them around £35. When this comes into place, you're going to suddenly start paying them £123. So again, you're going to suddenly start seeing impact quite quickly within your sort of budget lines. So again, amending forms and policies, ensuring HR systems and workflows are working for you and all the eligibility rules are in there. Again, it's going to be liaising with your payroll departments, making sure that they have this on their radar, because whilst this is a massive upheaval in HR, have your payroll systems picked it up and know what they need to do to make sure your systems are paying people correctly, because not paying statutory sick pay can cause you to face fines. Okay, and just to let you know, if your payroll is with Menzies, they are aware and they have got it on their radar, and it is going to happen as of April. So you aren't going to need to sort of chase them up and harass them to get it done for you. Again, you're going to need to communicate with your line managers, providing clear guidance on all employees being eligible, and that it's from the first day of sickness and from when they started in employment with you, so day 1, because these are all going to be quite significant changes for your managers to be managing those absences. And again, it's about training your managers, because with possibly more absences in your business, you're going to need to make sure you've got a robust absence management process and policy, and that you're sticking to it and following it and keeping it consistent across your management team. So again, training is important. If we could move to the next slide, please, Sandra. Okay, so paternity leave becomes a day 1 right. So by day 1 right, we mean that it happens from the first day that person walks into your business. This was previously a 26-week service requirement, and that has been removed. But the statutory paternity pay piece still has the 26 weeks continuous service requirement. So that remains in place to pay people. And there are wider consultations happening around family-friendly policies, so expect further change, because they're still out consulting on some of the pay elements of this. So again, you may find that you have more employees who will be requesting the leave. You're going to need to review those policies and contracts and make sure that it's all up to date and aligned with the new changes, ensuring your HR systems are aligned as well. But the big thing you need to remember and stress with your management team and anyone recording these is that the entitlement to leave becomes a day one right. However, the entitlement to the pay element of paternity leave isn't. That still requires the 26 weeks at the 15th week before confinement. So sort of 15 weeks before the mother goes off, they need to have had 26 weeks service. Again, it's just about making sure that it's clear and your systems are able to differentiate from somebody taking paternity leave who hasn't hit that target and people taking paternity leave that have met that. Okay, and if we could move on to the next slide, please. So ordinary parental leave. So again, the Act provides the removal of the current qualifying period of 1 year's service to be eligible to take parental leave, making it a day one right. Now, this is going to be one of the lesser known and possibly lesser used of the family-friendly policies. Basically, what this is every employee who is a parent of a child under the age of 18 and who has or is expected to have responsibility up to their age of 18 can take up to 18 weeks unpaid leave, and the unpaid bit is crucial here, before the child's 18th birthday to care for the child. And this is per child. So if you have 2 children, you have 36 weeks. That might be wrong. On the spot maths there. Not good. That's why I'm not in payroll. But again, like I stated, this is unpaid leave. So lots of people don't take it as an option, but you need to know it's there now and people can take it from day one. That's really the change there. So again, you may see a possibility of increasing parents taking this leave. So again, it's updating policies and ensuring your team are aware that this is a change that could possibly reach them. Next slide, please. So work placement harassment. Sexual harassment will become a qualified disclosure under whistleblowing law. Whistleblowing is the act of reporting suspected wrongdoing or risk of wrongdoing relating to sexual harassment where it is in the public interest to make this report. So again, in October of 2024, changes came in that employees needed to now take a proactive approach in preventing sexual harassment at work. In other words, employers must anticipate situations in which workers may be subject to sexual harassment in the course of their employment and take actions to prevent that harassment from happening. What's really happening here with the sort of adding it to the qualified disclosures for whistleblowing is that it's just giving people protections around discrimination, detrimental behaviour, detrimental treatment even rather than behaviour. Previously, whistleblowing has been much more around legalities, breaking laws, health and safety. So this is sort of a change and a step into sort of a more sort of people-centric place. But again, it has to be in the public interest. And really to note that within your harassment policies already, you should have protections in there for people making these claims. Sort of, you should have a bit about victimization. So this isn't going to be something new. If your policies are robust enough, it will already have been covered. So I think really here, the takeaway from this one is that just ensure your policies and procedures are in place and ensure that you're taking all reasonable steps to protect your employees from all forms of harassment. So again, it's making sure your whistleblowing policy is up to date, making sure that the team are aware of whistleblowing, what it means and how it can be reported on. But also it's making sure that you have completed a sexual harassment risk assessment for your business and that this is regularly reviewed. Therefore, you're preventing these allegations of sexual harassment from arising in the first place. Have you got those reporting lines in place that people understand and know where they can go? And have you got it clear that how you're going to respond to those so that people know that they are going to be heard and listened to? Because that's when you'll not see these claims coming through under whistleblowing or through your sort of grievance processes. It's making sure you've got those robust things in and making sure your managers are able to understand and spot those things. Right, and if I could go to the final slide, please, Sandra. Okay, so Fair Work Agency. Now, this is a new body that's being formed in April. So we know it's going to be called the Fair Work Agency, and it's going to be a single place where workers and employees can seek help. The Fair Work Agency will combine the Employment Agency Standard Inspectorate, the Gangmasters and Labour Abuse Authority, and HMRC's National Living and Minimum Wage in a single enforcement body. to take on the enforcement of a wider range of issues. So in terms of the proposed powers include extending enforcement powers for SSP and holiday pay, and what that means in terms of making sure that business are paying them and doing as they should. The next point is sort of bringing tribunal claims on behalf of workers when they are not planning on bringing that claim themselves. So if the Fair Work Agency thinks that your business is, excuse me, doing things that they shouldn't be doing, they can choose to put a tribunal claim in against your business without the workers saying, yes, I want that to be the case. They will allow for legal assistance with cost recoverable from the guilty employees. So again, this is helping those employees who haven't raised those claims previously have an avenue to do it because of the financial implications. And again, there will be additional financial penalties on employees. But what I will just caveat this with a little bit is that whilst this is a newly formed body, so we don't know what it's going to look like. We don't know what reach it's going to have, and we also don't know how much resource it's going to have to be able to police this, get those investigations done, and things like that. So as it unfolds, we will let you know. We will keep you updated. But really, truly, it's forming. We know it's got these powers and what they're going to be able to do, but we don't know how they're going to be able to do that and what that looks like in reality for yourselves. I'm going to hand over to Lorna now, who's going to take you into October 2026.
Hello, good morning, everyone. So can I have the next slide, please? Yes. So I'm going to talk about the extension of time limit for tribunal claims. So the current time limit for individuals to bring claims against discrimination or unfair dismissal claims is 3 months. From October this year, the time limit will increase to 6 months. This effectively doubles the period that people have to bring a claim. It means that you have a longer window of potential exposure, and employees have more time to seek advice and to decide whether or not they will pursue a claim. So what does this mean in practice, and how can you prepare? First, it's worth reviewing the processes that you have in place to resolve issues informally. Indeed, this is best practice and what we always encourage people to do. We always encourage people to try and resolve things informally in the first instance, because this prevents matters from escalating into formal disputes or tribunal claims. Secondly, record keeping becomes even more important. You'll want to make sure that you're holding accurate and up-to-date records, including notes of meetings, emails that you've sent to people, performance discussions, and any steps that you've taken to address concerns. Having this information readily available means that if a tribunal claim is brought, you have the relevant data and evidence to respond effectively. Can I have the next slide, please, Sandra? The next change to be aware of is the use of so-called fire and rehire practices, also regarded as dismissal and re-engagement. This has been in the news before with the tour operator, P&O Ferries. So the Employment Rights Act 2025 will make it automatically unfair to dismiss an employee for refusing a restricted variation in their contract. A restricted variation is quite important. It's one of those things, it's related to pay, working time, and variation clauses. So in terms of pay, it means that you won't be able to just reduce people's pay or remove any amount that's related to work done or any variation related to pensions without consulting people. You won't be able to do that with just dismissing them. Working time as well, you can't just reduce people's hours. You just can't sort of change the timing that they work, the duration of a shift, or reduce their annual leave. And then variation clauses themselves, any attempt by yourself to introduce a clause that will allow you to unilaterally alter terms and conditions won't be allowed. So now you have to have meaningful consultation, exploring alternatives, and genuinely seeking agreement with your staff rather than relying on dismissal and re-engagement as a last resort. Enforced contractual changes will carry a much higher legal risk in most circumstances. But whilst this might sound quite restrictive, there are exceptions, so breathe in a sigh of relief. If the business is experiencing financial difficulties and unable to carry on trading, you should be able to use them. However, you'll be able to justify your reason. So what should you be doing now and prepare for the change? If you operate in an industry that currently uses or considering using fire and rehire practices, it will be important to stay ahead of the developments and consultations around the proposals. The legal landscape is still evolving and keeping up to date will be important. There is, however, a statutory code of practice on dismissal and re-engagement, and this applies from July 2024. It sets out what your responsibilities are when proposing contractual changes, and you can find that on the government website. And of course, if you need any help on that, you can contact us. So careful planning, meaningful consultation, and adherence to the code will be essential to manage risk in this area. Next slide, please. I know that Beck talked about workplace harassment earlier on. These protections around harassment relate to sexual harassment and any harassment related to discrimination. Previously, in October 2024, the government brought in the responsibility to employers to have a preventative duty for to ensure that there wasn't sexual harassment in the workplace. However, they've now strengthened that, so you now have to show that you took all reasonable steps to prevent sexual harassment in the workplace rather than reacting when an issue arises. The Act also introduces employer liability for third-party harassment. So you can now be held liable for harassment that your employees receive by third parties, such as customers, clients, or contractors. So having clear policies, effective training, and practical measures in place will reduce the risk of harassment occurring. What should you do to prepare for this? If you haven't already, because this came in October 2024, you'll need to carry out risk assessments to identify areas or situations where sexual harassment can occur. Things like customer-facing roles, lone working, social events like Christmas parties, for example, your summer parties, and online interactions. Once those risks are identified, you should then put practical actions in place to prevent issues happening. You'll also need to review your harassment policies and procedures, especially those around how concerns are reported and how complaints are handled. These should be clear, accessible, and reflect the updated legal duties. Training is also a key area. You should consider training for managers and all staff to build awareness of what constitutes bullying and sexual harassment, and to reinforce that preventing this behavior is everyone's responsibility. Finally, it's worth noting that further guidance is expected in 2027. So this is very much an evolving area. Again, keeping your approach under regular review will be essential. Next slide, please. This change relates to tipping policies, and in particular, the requirement to consult employees on how tips are allocated. It's a further enhancement to the rules that came in October 2024 about distribution of tips. This will especially be relevant to businesses in hospitality and leisure sectors. So you'll now be required to consult with employees when developing their tipping policies. So this is about transparency and ensuring that workers understand and have input into how tips are distributed. Where there are recognized union or employee representatives, consultation should take place through them. If there are no representatives, the consultation should be taken with the employees directly. The key takeaway is that tipping policies should not just be documented, but actively discussed, reviewed, and kept under regular review. They actually have to be reviewed at least every 3 years. So what do you need to do to prepare for these changes? First of all, take time to review any existing policies that you have on tips, your current consultation processes, and to make sure that they align with these new requirements. This includes how tips are allocated, how decisions are made, and how employee input is captured. Secondly, make sure that your managers are fully aware of the upcoming changes. They should understand both your organization's tipping policies and the processes for consulting with employees, as managers are often the first point of contact for questions or concerns. So clear understanding and consistent application will be key to ensuring compliance and maintaining trust with your employees as well. Thanks for listening, and I'm going to hand over to Chris now.
Just jump in there and will honour and just remind everyone that if they have questions, please to put them in the Q&A so that we can come back to them later. Just a little reminder. Thank you.
Thanks, Lorna. Thanks, Ed. Good morning, everybody. Yes, so let's look further ahead to the changes coming in 2027. Can I have the next slide? Thanks, Sandra. So one of the big talking points has been the proposed restrictions on the use of 0 hours contracts. Now, it's important to note the detail around this is still being developed and implementation is not expected until next year. Consultation is continuing on these measures and hopefully will make the arrangements more workable. We're struggling to see currently how it will work in practice. But anyway, this is how it stands at the moment. Firstly, it doesn't mean there will be an outright ban on such contracts. Under the proposals, where someone's worked regular hours over a defined reference period, employers would be required to offer these in a formal contract. This represents a shift away from open-ended 0 hours arrangements and towards greater contractual certainty. For employees, this means more predictable income and working pattern and a clearer understanding of their rights. There are also proposed changes around shift management. Employers would need to provide reasonable notice of shift changes or cancellations, recognising the impact that last-minute changes can have on workers' finances and personal lives. And employers will also need to pay for cancelled or curtailed shifts. So the obligation will be on the employer to offer qualifying worker a guaranteed minimum number of hours after they have worked a 12-week reference period. Employers must offer workers a new contract that reflects the hours worked during the reference period and specify the days of the week and the times when the employer will make such work available. Employees can reject the offer of a regular hours contract, but there will be an onus on the employer to continue to monitor the hours worked and make further offers in future reference periods. For employers that use 0 hours workers to manage demand, there's nothing to prevent them from engaging workers for fixed periods, for example, when there's a higher level of demand for delivery services over Christmas. The bill states that employers may offer limited term contracts in certain circumstances, such as where the worker is employed to perform a particular task or where the worker is only needed until the occurrence of an event, and then the contract will reasonably come to an end. Meanwhile, it gives businesses time to review current working arrangements and how working hours are recorded. Keeping clear records of hours worked in any reference period will be key when assessing where guaranteed hours should be offered. You may also need to consider whether alternative contract models may be needed to comply with new legislation. And one final point on this topic, following consultation, the government have also amended the Act so that agency workers are included, with the obligation to make an offer of guaranteed hours falling on the end hirer. If you employ agency workers, you should speak to your agency, ensure your terms of them don't leave you exposed. Next slide, please, Sandra. Right, another important change to be aware of is the increased protection from dismissal for pregnant employees and those on or returning from family-related leave. Previously, the legislation only referred to redundancy, where it is now any type of dismissal. Under these proposals, it would be unlawful to dismiss a woman, except in very specific circumstances, while she is pregnant, as well as during her maternity leave, and also for 6 months after the employee's return to work. Now, if you think most expectant mothers tell their employers of their pregnancy once they've had that first scan at 12 weeks, so 3 months, you're then looking at 6 months remaining of the pregnancy, up to a year of maternity leave, and a further 6 months when they return. So 2 years essentially, and that significantly extends the window during which these additional safeguards apply. The Act also includes those who are on and returning from adoption leave, shared parental leave, and neonatal care leave. The aim is to ensure that employees are not disadvantaged or treated unfairly because of pregnancy or their decision to take family leave, particularly at key transition points such as preparing for leave or when they're reintegrating back into the workplace. For employers, this means ensuring your managers are trained in managing restructures, role changes, or potential dismissals affecting individuals who fall within these protected groups. There will be circumstances where these protected individuals will be impacted, and it will be critical to ensure any decisions are fair, well documented, and compliant with the enhanced protections in order to minimise any risk of a discrimination claim. Next slide, please, Sandra. Okay. And finally, in 2027, another area seeing important procedural change is the right to request flexible working. Now, you'll recall the legislation was updated back in 2024 to make it a day one right to request flexible working and to allow employees to make 2 statutory requests within a 12-month period. And this is still the case. The focus here is on how the requests are handled. The proposed changes are designed to make the process more accessible, transparent, and consistent, encouraging open dialogue between employees and employers, meaning employers would be expected to engage more meaningfully with requests, considering them carefully and responding with clearer timeframes. The emphasis on constructive discussion rather than simply accepting or refusing a request at face value. I would expect to see in-depth discussions with the employee to understand the needs behind the request and then coming to a reasonable agreement. It will also, where a request cannot be accommodated, employers would still be able to refuse it, but decisions need to be clearly based on legitimate business reasons and clearly explained. Again, a meaningful discussion with the employee to ensure they fully understand the reasons will be key. And this helps the employees better understand the rationale and also supports fairness in decision making. It will be really important to ensure that your managers are fully trained in how to manage these requests. It's very likely that those making these type of requests are going to be people with caring responsibilities or disabilities. And so having a clear and well documented decision, making it defensible, will be really key to avoid any discrimination claims. That's all from me. I'm going to hand on to Ed, who's going to talk about trade unions.
Bruce, you'll be pleased to know we're nearly at the end of the content, and I'm not going to take very long over this at all. There are some trade union reforms. Most of our clients, I would say, are not unionised, but there are a couple of things just to look out for here. So next slide, please, Sandra. There are 2 things happening. There's phase 1 that's happening basically now in February. And then there's another phase that's happening later in the year. Phase 1 is just about industrial action. So this is where the Labour government have repealed a lot of the restrictive legislation that the previous government put in place to make it harder for unions to take strike action. So a lot of those hurdles that they put in the way are now being removed by the new legislation. And that's all I'm going to say about that. If you're in a situation where there is industrial action coming, then obviously happy to pick that up with you separately. The next one, which is more widely relevant, is that there's always there are existing laws that make it possible for employees in the UK to gain trade union recognition in their business through a statutory recognition process. And these phase 2 changes later in the year are going to make it easier for that to happen. So they include lower thresholds for demonstrating support, a reduced emphasis on providing majority backing, etc. So they're lowering the bar for this recognition. And in October, interestingly, right at the bottom there, 2 things happening. There's going to be a duty on employers to inform workers of their right to join a union, which is something that you'll probably be required to put in your contracts of employment. And they're talking about new rights for unions to access workplaces to meet and organise workers. Now, obviously, the thought of that will send shivers up a lot of employers' spines, I've no doubt. And actually, the practicality of that is like hard to understand what it might look like. And so there's going to be further guidance on that in terms of exactly how that one might be achieved. So watch this space on that. But of course, the emphasis it places is on ensuring you've got good workplace relationships, you've got a good industrial relations environment, you've got good employee engagement, your communication and ability to resolve issues quickly and it is all in place. So good practice in all of those areas is obviously going to minimize the demand that might come up at some point for employees to try to seek union recognition. Okay, so that concludes the input. I'm sure you're delighted to know, and you may well be feeling a little bit bamboozled. We're going to come on to just talk about what you might want to do. We've been mentioning things as we've gone along, but Lorna's just going to pull together some of those strands into a little idea as to what steps you might want to take. Before she does that, I just want to make a one comment about the need to focus on this, because from what we've heard already, you can see that the risk factors, which we normally talk about in terms of claims risk, you know, there's a lot of upward pressure on that. There are a number of factors working together. So you can make a claim sooner, you've got longer to make it, you've got more statutory protections, there are greater demands on employers to take steps, and you can achieve much higher compensation at the tribunal. This does place an upward pressure on employers. And by the way, the government estimated that the cost of implementation of this, which doesn't include tribunal awards, obviously, but just the cost of implementation, were going to be around £1 billion across the economy. But they recognise that there's a disproportionate effect on smaller businesses and micro businesses. So, yeah, just wanted to set that scene before we talk about solutions, and I'll hand over to Willorna to take that piece.
Thanks, Ed, and thanks everyone for listening so far. I know it is a lot to take in. Can I have the slide, please, Sandra? So, first of all, I guess it's best to just take a step back for now and think about how this legislation might impact on your business in practice. Obviously, that's going to vary from business to business. So understanding where your particular risks and pressures sit is key. And then from there on, review and update your key workplace policies and procedures to make sure that they remain fit for purpose and are aligned with the new duties that we've just discussed. So you'd need to perhaps look at your contracts. I know we talked about probation periods earlier on. You might want to look at amending the probation period that you have on your contract, for example. And then obviously, it goes without saying that you have to look at your recruitment, onboarding, and performance processes, because you need to make sure that these are strengthened so that you can support early engagement, clear expectations, and consistent management. Another recurring theme is the value of resolving issues early. So improving informal processes for dealing with concerns can help prevent escalation and reduce the risk of tribunal claims. Again, managers are always the first point of contact for employees. There's an old saying that people leave managers, not companies. So make sure that your line managers and staff understand their new duties and expectations, particularly around consultation, prevention, and record keeping. And speaking of records, ensure that your systems support accurate and accessible record keeping. So that's your HR information system, that's any sort of filing storage that you have, because this can be crucial if issues arise months or even later or years later. For example, people now have 6 months before they can bring a claim, whereas it was 3 months before. Finally, this is not just a one-off exercise. Keep abreast of ongoing developments and plan ahead for further guidance as it emerges. We will be putting on further webinars. We usually send out blogs to a client, so we'll keep you posted. I know this is a legislative piece, but it also, on the other side of the scale, let's talk about creating a good, engaged, and productive workforce. So now it's time to really focus on your people. You need your people in your business to get profitability and for things to work out. So having a positive workplace culture will help. Thanks for listening, and I'll hand over to Chris. Sorry, to
I think it's
Ed.
back to me. Thanks, Lorna, and that's a great message there just to end on. Just a quick reminder then, and it's wonderful to see so many of our clients on the webinar today, but just in case you're not, just to let you know the ways in which we can help very quickly. Thanks, Sandra. Next slide. Lorna's alluded to many of these things. So starting with a risk assessment, that's something we can support. Training for managers, management skills, very critical, knowing how to use processes, absence, performance, discipline, all of those things are going to be much more critical. So having managers who understand how to operate those and also how to defuse situations before they get too big. Training for employers, compliance training is going to be routine stuff, is going to be important. We have e-learning solutions for that. Improving your procedures and processes obviously has been something that's come up throughout. Helping to develop that culture and engagement piece that Lorna just mentioned. Updating contracts and policies, and I've seen there are a couple of questions that we'll come to about that in a second. We also have an advice line, and Chris and her team help clients with HR systems and back office, so all of that admin and storing data and mapping processes and ensuring that you're capturing all the right data in the right place. So just very quickly to say that if any of those things are something you need assistance with, we're obviously here to help. So next slide. Thank you, Sandra. We're going to come on now to a quick poll. We are going to come to questions in a sec. So please while you're doing this, put any questions that you still have into the Q&A. We've got 10 minutes left at the end to try and deal with those. For now, though, if you wouldn't mind, there's a couple of poll questions. First of all, the things, and we focused here mainly on the things that are coming up in 2026. So some of the things that are coming later, we need a bit more detail on yet. But certainly for the more immediate issues, we'd like to get a feel for the ones that you're most concerned about or where you feel you'd like more information. So if you could answer question 1. And then in question 2, anything that you'd like to hear about from us in terms of assistance you might require. So we're just going to give you a few seconds to complete that whilst you also post any other questions you have in the Q&A, and then we'll come on to questions. Okay, so I can see that there are some questions that have come in. And we did also have a couple of questions ahead of the webinar, so thanks for those. So let's move to those now. And Sandra, would you like to throw us a question?
Yes, hello everybody. I can see quite a few questions are coming through, so keep them coming. Just before we get to those, we did have a few pre-submitted. So if we could start with those. The first one is, should I consider running this past our legal team for employment contracts?
Yeah, I think the answer to that is, yeah, if you've got a provider who helps you with your contracts, which could be us, in many cases it is, then yes, you should think about the changes that you need to make. Now, actually, after this webinar, we're going to send something out to you that helps you to identify the kind of areas that you might need to look at in your contract that summarizes those areas. So we'll send that out to everyone who's attended. But yes, you should look to how you need to amend your contracts going forward and your policies.
Thank you. The next question is, if we offer 10 days paid sick on a rolling year period and an employee has used all of those 10 days, can we refer them to use SSP?
So SSP is not something that you refer people onto. I'm assuming from that question that you might be paying 10 days company sick pay for the first 10 days. SSP is a statutory right to a minimum pay and it's a very complicated rules on SSP, but it covers a 28-week period. I'm going to ask Beck or anyone else to jump in here in terms of anything I'm getting wrong. But the way it works is it's a statutory entitlement that a minimum that the employer must pay. So if, for example, you've got in your contracts that the company will pay 10 days company sick pay for the first 10 days, if those 10 days are used up, what then happens is that SSP entitlement carries on running for the rest of that 28 weeks. So that formed part of those 10 days full pay at the beginning, but the rest of that SSP entitlement keeps on running until it runs out, which is after 28 weeks or so. I hope that answers the question. I don't know if anybody else has got any comment to make on that.
And well, I was just going to add to that, in fact, Ed, in terms of sometimes we think of people taking 10 days company sick as a block. It would be the same if they took those 10 days over the rolling year. Once they've used all 10 days, they move on to the sort of statutory sick pay levels and stuff like that. So people should, once they've exhausted company sick pay, be moving on to those things. And again, I would say in terms of making sure your payroll systems have that flagged, make sure the rules are put into the background of your payroll system so that it's an automatic thing for you guys, so that it's not something you have to think about. Lots of payroll systems are able to put in rules that allow for that. This person taken 10 days of company sick, now they need to move on to that. So again, it's about managing that sort of reporting and ensuring that's done properly and in working with your payroll provider. But yeah.
Expect Sandra, next one.
So we've got a two-part question. So the first part is the company under any obligation to present the changes proactively to the employees? And the second part is, do existing employment contracts require updating due to the Act?
Okay, so first part of that question, there is no duty to present what's going on here to employees in the way that we have today. Now, obviously, those employees are going to get informed of certain things because of updates that you're going to need to make to your policies, etc. But there's no need to proactively tell them. The one thing I would just come back to in terms of a proactive duty, you have a proactive duty around the prevention of sexual harassment. And that has been, as colleagues have already said, that's been in place since October 2024, but we know that there's a lot of organisations who haven't yet really tackled it. Well, with the ratcheting up of these harassment, kind of protections and things, it's going to be more and more important that proactive duty you are taking on board and thinking about how you're addressing it in the ways that Beck and Lorna have talked about. So that would be my only tip on that one. I've completely forgotten the second part of that question, Sandra, sorry.
No worries. It's do existing employment contracts require updating due to the Act?
Would someone else like to take that one? Because I don't know if everyone can hear it, but someone's decided to start drilling next door. I don't know if it's annoying you, but it's certainly annoying me. So I'm going to mute myself for a second.
Go for it, Ed.
Yeah, sure. I think that it is worth looking at your contracts to see what you might need to change. So I know we talked about unfair dismissal and the probation periods and things like that. So if, for instance, you have a 6-month probation period at the moment, you may wish to change that to be a 3-month probation period. And it will be worth looking at contracts quite tightly now, because with the restricted variations that I talked about earlier on, it will be more difficult to amend people's contracts now. So it's definitely worth looking at your contracts. And remember that whatever's in your contract has to sort of align with your handbook. So with contract changes, mean also having a skim through your handbook to make sure that things align.
So the next question is about the paternity leave. Day one rights paternity leave, up to how many is available in one financial/tax year? And is it compulsory for these to be paid or unpaid?
Right. So paternity leave comes off the back of having a pregnant partner. So there will be a level to how many times you're going to take paternity leave in any 1 year. I mean, because obviously a pregnancy takes 9 months to happen. So, but again, it will be on individual circumstance, but I would imagine you're not going to get more than one person taking 2 bouts of paternity leave in any 1 year. And to do with the pay thing, it'll be very much dependent on their length of service. So it might be, say, they join you day one, they tell you they need to take paternity leave, they can take the paternity leave, but that one will be unpaid. Then come 9 months later, they're saying, I need to take paternity leave again. That one is more likely to be paid. So again, it's going to be case by case, but paternity leave, I wouldn't imagine you'll see one individual taking more than 2 just because of the length of pregnancies. With paternity leave, much like maternity leave, it's per pregnancy, not per child within the pregnancy. So you don't get extra if you have multiple birth. So I hope that answers the question. If not, let me know.
Thanks, Beck. So moving on, I believe this question is about the unfair dismissal piece. Are there employer protections / insurances to protect employers from the unlimited cap?
Great question. There are insurances that companies do have in place that protect them against claims in the tribunal. I have no doubt that they will remain in place, but you know what's going to happen because of the increased potential awards. I expect the premiums will go up, but those policies do already cover companies for other types of uncapped claims, like discrimination claims, for example. So I think, yes, speak to your insurers. I dare say their policies will adapt to this, but their risk is going to go up. And so I dare say, so will your premium.
Thanks, Ed. Back to SSP. We have a lot of staff just off sick for 1 day with headache or just feeling sick. Will they now be paid that day?
Yes, in simple terms. Yes, it's from when they start employment with you, and it's from day one of sickness. So again, those people that have the odd headache, the odd feeling a little bit sick, even if they're just taking 1 day's absence, yes, they'll need to get paid it. And that's why earlier on when I mentioned it's about getting those robust processes in place, it's about having a good absence management process, because you will see more people taking those 1 day absences, and then you're going to need to therefore manage them and make sure you've got trigger points in your policies and processes.
Thanks, Beck. Next question is, where new labour law affects basic contractual terms, do we always need to update contracts, for example, when it comes to the new sick leave rules?
So you need to consider what is contractual, because there are some aspects of all the items we've talked about that may impact a contractual term in the contract, and others that may just be policy matters that you need to reflect in your policies, but which actually aren't actually contractual. So you do need to have a careful look at changes that are driven by this that will affect a contractual term. For example, if you change, as Lorna mentioned, if you change your probation period, that should go in the contract. But issues relating to changes in parental leave, for example, that would just be reflected in a policy. So you need to discern it.
Can I jump in? I think in terms of the contracts, I think a lot of contracts where companies only pay SSP and they don't have enhanced sick pay, a lot of contracts just simply refer to SSP and not the nitty-gritty detail. So you may find a contract doesn't need adjusting in those circumstances, because although it references SSP, it doesn't talk about when it's paid and when it's not. So although the details change, there may not be a need to change a contract.
Good point, Chris. Thanks. So I think, have a look. You need to assess what you've got, and obviously we can help.
Perfect.
I'm aware that it's sorry, just to say, I'm aware that it's 10:30. So if you have to leave at this point, then thank you so much for attending the webinar. We will. We're not going to get to all the questions, I don't think, but we will come back with those answers for people who've raised it, and we may put a little bit of a Q&A thing into the follow-up, just to let you know. We can certainly stay online for another 2 minutes. We'll answer, say, another two questions, and then we'll finish. But if you have to go now, thank you, and we will be in touch with you with the recording and the slides, and we hope to see you again next time. But Sandra, let's do two more.
Okay. So are we required to update our employee handbooks for all these changes?
Would be a good idea to, I think, is the short answer.
Yeah, and I think just for those on here that are clients already, where we've supplied your handbook, we will, over the course of these changes coming into effect, we'll be in touch to advise you what needs to be updated. So I noticed there was a couple of questions from people that were asking about will we support them. So I just wanted to drop that in.
So let me just choose one last question to ask. So this person works in social care, and regarding bank staff, would the changes be applicable to staff on a bank contract who may only pick up shifts as and when available?
I saw that question come in, and I think it's a really good question. And I'm not surprised you're asking it because obviously, where you've got bank workers, that the implications on this are quite large. I actually would like to follow up with the person who asked that question because it's not that simple. I mean, for example, it depends what category those people are in. They might be an employee, they might be a worker, and if they're a worker, they don't have quite the same protections as an employee. So I think there's a few things to unpick in that question, that we're not going to be able to summarize. It does need some examination. So I'd very much like to go back to that person who's asked that question. And if anybody else is in a similar situation with bank workers or large cohorts of 0 hours workers, for example, then please do get in touch because those are areas where it is going to be important to unpick exactly where the impacts of this are going to be felt. I mean, I noticed someone else asked a question about do 0 hours workers qualify for SSP, and the answer to that is basically yes, but the application of it is really complicated. So please come to us with any of those. So, is that it? Was that two questions? Sorry, I've lost count.
That was two questions. We do have a lot more, but we'll get to them after the
Yeah.
webinar,
Okay.
in our follow-up email.
Thank you, Sandra, and thank you everyone who's still online for all of the questions and for your participation today. We will send more information out, some helpful guidance, some checklists, some answers to those questions, and as I say, the link to the presentation. Our contact details are there, and please do follow up with us if there's anything else that you need. But for now, good luck, have a nice day, and hopefully we'll be in touch again soon. Thanks.